Hello, everyone. Today's case is Landor v. Louisiana Department of Corrections and Public Safety. So this is about a person went to prison and they were a Rastafarian and they had their hair a certain way based on that religion. I don't know too much about it, but they go to prison and then the police are like, or the corrections officers are like, "Hey, you can't have your hair like that." And he's like, "But it's like my religion. I'm allowed to." And then they just cut it off. So that's pretty wild. But let's see what they said. The Religious Land Use and Institutionalized Persons Act of 2000, RLUIPA, was enacted pursuant to Congress's spending clause authority and imposes various conditions on federal funds distributed to state prison systems in, like the Louisiana Department of Corrections, LDOC. One condition requires state prison systems to agree to answer federal suits by private plaintiffs alleged certain substantial burdens on their religious exercises. Relying on that provision, inmate Damon Landor brought this Arlupa case or Arlupa lawsuit against LDOC as well as some of the prison system's individual officers in their personal capacities seeking damages from them. Mr. Landor is a Rastafarian whose religious convictions require him to leave his hair uncut. He claims that LDOC officers, despite being aware of his religious beliefs, forcibly shaved his head. The officers moved to dismiss, arguing that while their employer LDOC may have agreed to answer certain private suits under Arlupa, they are not parties to any such agreement, and therefore Mr. Landor had no federal cause of action against them. The district court dismissed Mr. Landor's Arlupa claims against both the officers and LDOC. On appeal, Mr. Landor challenged only the dismissal of his claim against the individual officers. The Fifth Circuit declined to revive that portion of his suit, holding that Arlupa does not permit suits against officers in their individual capacities. Held. Individuals may not be held liable in their personal capacities under a spending clause statute unless those individuals have voluntarily and knowingly consented to answer lawsuits under the statute. Because the individual defendants in this case did not voluntarily and knowingly consent to face Arlupa liability in an agreement with the federal government, Mr. Landor's case cannot proceed against them. While the Constitution's spending clause may confer on Congress the power to spend money for the general welfare, it does not endow Congress with any power to regulate conduct. Congress may attach conditions to the funds it distributes, and if a recipient violates those conditions, Congress typically may terminate its agreement to provide funds. But Congress cannot dictate whatever other sanctions it might wish for violating conditions found in its spending clause legislation. Additional sanctions are permissible only with the voluntary and knowing consent of those who must bear them. To sort out whether consent exists, the court has traditionally employed a contract analogy that helps to ensure conditions attached to federal funds, including those prescribing exposure to potential sanctions, apply only to those who have knowingly and voluntarily agreed to them. These settled principles resolve this case. Before this court, LDOC does not dispute that it is a recipient of federal funds and has agreed to answer certain RLUIPA suits as a condition of accepting those funds. But this case involves only claims against individual state employees in their personal capacities, and Mr. Landor does not allege that any of those individuals has entered any agreement with the federal government, let alone that any of them has voluntarily and knowingly consented to answer private suits under Arlupa. Because they never agreed to answer suits like this one, Mr. Landor's case cannot proceed against them any more than a breach of contract action might proceed against a defendant who never formed a contract. Mr. Landor's arguments are all variations on the theme that the lack of voluntary and knowing consent does not matter, and they all fail for that reason. Under the spending clause and the court's precedents, the consent requirement is key. Mr. Landor invokes agency law, arguing that LDOC employees may be held liable because they are LDOC's agents. But as a matter of black-letter law, when a principal enters a contract with a third party, the principal's agents do not become liable to the third party for their principal's non-performance. LDOC might be subject to certain private suits under Arlupa if it breaches its promises to the federal government, but it does not follow that LDOC's employees are as well. Mr. Landor next turns to South Dakota v. Dole, arguing that his proposed cause of action satisfies Dole's 4 requirements and therefore satisfies the spending clause too. But Dole's requirements apply in addition to, not instead of, the rule that Congress may not use the spending clause to bind entities and individuals without their knowing and voluntary consent. Dole itself added a 5th rule barring compulsion and reaffirmed the clear statement rule, both of which serve to ensure real consent exists. Mr. Landor also argues that RLUIPA's mere existence sufficed to alert the individual defendants that they could be held personally liable. This argument fares no better. A spending clause statute assumes binding effect only through voluntary and knowing agreement, which is lacking here. Mr. Landor next turns to the fungibility of money, contending that the individual defendants are indirect recipients of federal funds because they receive paychecks from LDOC. But this argument would mean that so long as a penny of federal spending makes its way to an individual, Congress could directly regulate his conduct based on the fiction that he has consented to regulation. This is inconsistent with the requirement of knowing and voluntary consent, and it would give Congress an effectively unbridled police power impossible to square with the spending clause's terms or our precedents. Mr. Landor's reliance on the necessary and proper clause and Sabry v. United States is misplaced. In Sabry, the court held that Congress's criminal ban on theft, fraud, or bribery against a federal funding recipient is a necessary and proper incident to Congress's authority to spend money. Mr. Landor contends that his proposed cause of action is likewise incidental to RLUIPA's policy protecting religious exercises. But Mr. Landor is answering the wrong question. The correct question is instead whether such a cause of action is a necessary and proper incident to Congress's enumerated power to spend money. Suits against non-consenting parties, like the individual officers here, might advance RLUIPA's policy but do not safeguard federal funds from being frittered away in graft. Adopting Mr. Landor's proposed cause of action would allow Congress to evade the consent requirement inherent in its spending clause authority and regulate directly the conduct of countless non-consenting individuals in spheres traditionally reserved to the states. Such a result would be inconsistent with principles of state sovereignty and a federal government of limited and enumerated regulatory powers. Affirmed. Justice Gorsuch delivered the opinion of the court, in which Roberts, Thomas, Alito, Kavanaugh, and Barrett joined. Jackson filed a dissenting opinion, in which Sotomayor and Kagan joined. Justice Gorsuch delivered the opinion of the court. This case concerns whether the Religious Land Use and Institutionalized Persons Act of 2000 permits plaintiffs to sue non-consenting state employees in their private capacities for damages. Today, Congress offers financial support to all 50 states and many other entities. Much of that support comes with strings attached. So, for example, Congress has conditioned receipt of federal highway funds on a state's agreement to maintain laws setting a minimum drinking age of 21. Likewise, Congress has conditioned federal Medicaid funds on a state's willingness to administer its healthcare programs consistent with various rules. In each of these contexts and many others, the penalty for noncompliance is straightforward. Congress may terminate funds if a recipient fails to abide by the conditions associated with its grants. The statute at issue before us, the Religious Land Use and Institutionalized Persons Act of 2000, RLUIPA, works similarly. As relevant here, RLUIPA imposes various conditions on federal funds distributed to state prison systems like the Louisiana Department of Corrections, LDOC. One condition requires prison systems to refrain from imposing substantial burdens on the religious exercises of state prisoners outside exceptional circumstances. If a prison system fails to comply with that condition, Congress may cut off its funding. But when enacting RLUIPA, Congress did something more. It included another, distinct remedy as part of the bargain. As a condition of funding, Congress called on state prison systems to agree to answer suits by private plaintiffs alleging substantial burdens on their religious exercises. Specifically, the law asked those systems to consent to suit by any injured party asserting a violation of RLUIPA in seeking appropriate relief. This case concerns that provision. Damon Landor is a Rastafarian whose religious convictions require him to leave his hair uncut. In 2020, after a conviction in Louisiana state court, Mr. Landor spent a few months in custody. Near the end of his sentence, as officers transferred him from one facility to another, Mr. Landor grew concerned that the new facility's intake officers might cut his hair pursuant to standard LDOC grooming policies. To avoid that possibility, he provided the officers with a copy of Ware v. LDOC, which held that RLUIPA generally bars prisons from cutting Rastafarians' hair. But, Mr. Landor says, the LDOC officers in the new facility responded by throwing his copy of Ware in the trash and proceeding to shave his head, causing him to violate his religious beliefs. After that transpired, Mr. Landor brought this lawsuit under RLUIPA seeking money damages. He sued not only LDOC, but also some of the prison system's individual officers in their personal capacities. The officers responded by asking the district court to dismiss Landor's complaint. As they saw it, their employer, LDOC, may have struck a bargain with the federal government to answer certain private suits by prisoners like Mr. Landor. But they argued they were not parties to that or any other agreement to answer private suits under RLUIPA. Accordingly, they continued, Mr. Landor had no federal cause of action against them. Ultimately, the court dismissed Mr. Landor's RLUIPA claims against both LDOC and the officers. On appeal to the Fifth Circuit, Mr. Landor did not challenge the district court's dismissal of his RLUIPA claim against LDOC. Instead, he focused on his claim against the individual officers, asking the Court of Appeals to revive only that portion of his suit. The Fifth Circuit declined to do so. It did not question that RLUIPA may permit certain claims against funding recipients like LDOC. But, the court held, RLUIPA does not permit suits against officers in their individual capacities. We granted Mr. Landor's petition for a writ of certiorari. Before us, the parties dispute two questions. One is whether, by authorizing private lawsuits seeking appropriate relief, RLUIPA ever permits suits for money damages, or whether the statute instead limits plaintiffs like Mr. Landor to other remedies, like injunctions or declaratory judgments. The other question the parties spar over is whether, consistent with the Constitution, a plaintiff may bring an RLUIPA suit against individuals like the officers in this case, who have not formed any agreement with the federal government. To resolve this case, we need answer only the second question. Article 1 of the Constitution grants Congress certain limited and enumerated powers. Congress, for example, may regulate commerce among the several states. It may establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies. It may coin money and provide for the punishment of counterfeiting. These provisions and others allow Congress to regulate the behavior of the American people in specific fields, and each allows Congress to back up its regulations with a sanction enforced either by the coercion of the magistracy or by the coercion of arms. For example, federal statutes require airlines operating in interstate commerce to hold certificates and comply with federal requirements. The Bankruptcy Code allows a court to alter a creditor's rights and a debtor's responsibilities. And Title 18, Chapter 25 criminalizes counterfeiting. Each of these regulations finds its footing in a provision of Article 1 that empowers Congress to do just that, regulate. The terms of RLUIPA before us rest on a different foundation. As the parties agree, Congress enacted them pursuant to what is sometimes called the Constitution's Spending Clause. That provision of Article 1 gives Congress the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. At the founding, some argued this language conferred on Congress the power to regulate on nearly any topic it wishes, backed by practically any sanction it chooses, so long as it does so in service of the general welfare. It appears that Gouverneur Morris, a leading advocate of this reading and a member of the Committee on Style, even tried to replace one of the draft clause's commas with a semicolon, with the hope of making his reading more plausible. But a careful proofreader, Roger Sherman, noticed the surreptitious edit, and the convention rejected it. In the end, the founding generation rejected Morris's reading of the clause just as it had his semicolon. While the clause may allow Congress to raise and spend money in support of the general welfare, early authorities concluded it did not endow Congress with any power to regulate conduct. Were it otherwise, they recognized, the enumeration of specific powers elsewhere in Article 1 would be rendered largely pointless, and the nation would trade a limited federal government for an unlimited one. This court's precedents have long respected that founding era consensus. It is an understanding that gives rise to important limitations on spending legislation. Often, Congress attaches conditions to the funds it distributes, and typically, if a recipient violates those conditions, Congress may terminate its agreement to provide funds. But because the spending clause confers no authority to regulate directly, Congress cannot just dictate whatever other sanctions it might wish for violating conditions found in its spending clause legislation. Instead, additional sanctions are permissible only with the voluntary and knowing consent of those who must bear them. Put simply, without independent regulatory authority, Congress must rely on consent. It must ask and others must agree to face liability should they violate a funding condition. Time and time again, from at least 1845 to the present, our precedents have stressed the centrality of consent in this field. To sort out whether consent exists and thus whether a condition associated with spending legislation is enforceable, we have traditionally turned to contract principles for guidance. See Sossaman, the contract analogy represents a limitation on the liability spending clause statutes may impose. Consider some examples. At common law, coerced assent to a contract is invalid. Likewise, we have held coerced assent to a spending condition by way of an economic gun to the head is invalid. At common law, ambiguous contractual language is construed against its drafter. Similarly, we have concluded Congress must clearly and unambiguously alert a grant recipient to any condition on federal funds. In these ways and others, our contract analogy helps safeguard against conflating Congress's spending power with regulatory power. It does so by ensuring that conditions attached to federal funds, including those prescribing exposure to potential sanctions, apply only to those who have knowingly and voluntarily agreed to them. These settled principles resolve this case. Before us, LDOC does not dispute that it is a recipient of federal funds. It does not question that it has agreed to answer certain RLUIPA suits as a condition of accepting those funds. But as it comes to us, this case does not involve claims against LDOC. It involves only claims against individuals in their personal capacities. And Mr. Landor does not allege that any of those individuals has entered any agreement with the federal government, let alone that any of them has voluntarily and knowingly consented to answer private suits under RLUIPA. To know that is enough to know the Court of Appeals was correct. Mr. Landor does not have a federal RLUIPA cause of action against the officers. Under the spending clause, Congress lacks regulatory authority to impose liability on them directly and must depend instead on consent. And because they never agreed to answer suits like this one, Mr. Landor's case cannot proceed against them any more than a breach of contract action might proceed against a defendant who never formed a contract. Seeking to avoid this conclusion, Mr. Landor and the dissent advance many arguments, but each is a variation on the same theme. In different ways, Mr. Landor and the dissent submit the lack of voluntary and knowing consent does not matter, and each of their arguments fails for exactly that reason. Under the spending clause and our precedents, voluntary and knowing consent is key. Mr. Landor begins by invoking agency and contract law. As LDOC's agents, he contends, the individual defendants have a duty to obey all reasonable directions from their principal. And he adds, an agent's actions can sometimes bind his principal to a contract when he acts within the scope of his authority. From these common law principles, Mr. Landor reasons, it follows that the individual defendants in this case may be held personally liable under RLUIPA. That much does not follow even from the precepts Mr. Landor cites. Certainly, an agent usually must obey his principal's directions and sometimes may bind his principal. But when a principal, here LDOC, enters a contract with a third party, here the federal government, as a matter of black-letter contract law, the principal's agents do not become liable to the third party for their principal's non-performance. So yes, LDOC might be subject to certain private suits under RLUIPA for breaching its promises to the federal government, but under normal principles of agency and contract law, that does not mean LDOC's employees are as well. To be sure, Mr. Landor and the dissent identify ways in which Congress could have lawfully imposed personal liability on the individual defendants. For example, Congress could have said that, as a condition of federal funding to LDOC, its officers had to agree to enter separate contracts with the federal government, consenting to answer suits under RLUIPA. Or Congress might have conditioned its funds on Louisiana's agreement to exercise its own regulatory powers to adopt a state law cause of action enforceable against LDOC officers who violate RLUIPA. But these untapped possibilities only underscore Mr. Landor's bind. The first hypothetical has what this case does not, namely an agreement between the federal government and the defendants. And the second hypothetical, again unlike this case, the state would have exercised its own regulatory powers. Next, Mr. Landor points to Dole. That case, he says, set out just 4 requirements for spending clause legislation, and consent is not among them. As he reads Dole, a condition on the grant of federal funds need only be 1, in pursuit of the general welfare, 2, unambiguously expressed, 3, related to the federal interest in particular national projects or programs, and 4, not in violation of other constitutional provisions. And because a condition requiring non-consenting individuals to answer RLUIPA suits satisfies all of these requirements, Mr. Landor concludes, his case may proceed. The dissent appears to agree, suggesting that the voluntary and knowing consent requirement finds no support in any of Dole's prongs. That is incorrect. The 4 rules Mr. Landor extracts from Dole apply in addition to, not instead of, the rule that Congress may not use the spending clause to bind entities and individuals without their knowing and voluntary consent. That much is evident from Dole itself. As the dissent admits, Dole proceeds to add a 5th rule for spending clause legislation shortly after the passage Mr. Landor cites. Funding conditions may not pass the point at which pressure turns into compulsion. And that bar on compulsion, as we have seen, serves to help ensure real consent exists. The same holds true of the clear statement rule that Dole reaffirmed. Congress must impose spending conditions unambiguously, not for no reason, but so that participants in federally funded programs may exercise their choice knowingly, cognizant of the consequences of their participation. Had Dole meant to bulldoze the consent requirement and condone consent-free regulation under the spending clause, it would have had no occasion to emphasize any of this. Nor does Mr. Landor's and the dissent's consent-free gloss on Dole merely overlook important qualifications in Dole itself. Worse still, their misreading would pit that decision against nearly 2 centuries worth of cases recognizing the consent requirement, hardly a sensible way to construe our precedents. Responding to these problems, Mr. Landor and the dissent submit that RLUIPA's mere existence sufficed to alert the individual defendants, or at least their employer, that they could be held personally liable. But just like the attempt to rewrite Dole, this argument misses the point. A spending clause statute does not carry independent regulatory force. It assumes binding effect only through voluntary and knowing agreement. If someone has not agreed to be bound, it does not matter that he may be aware of the existence of a contract between other parties. And if someone has not agreed to be bound, it does not matter whether other contracting parties might wish to bind him. Either way, he has not agreed to be bound, so he cannot be. Seeking still another way around the consent requirement, Mr. Landor turns next to the fungibility of money. The individual defendants, he observes, receive paychecks from LDOC, and some of that entity's funding comes from the federal government. As a result, Mr. Landor submits the individual defendants are indirect recipients of federal funds and, for that reason, should be deemed to have implicitly consented to RLUIPA liability. This submission fails as well. Mr. Landor would have us hold for the first time that so long as a penny of federal spending makes its way to an individual, however indirectly, Congress can regulate his conduct directly based on the fiction that he has consented to regulation. None of that is consistent with our precedents, holding that funding conditions in spending clause legislation lack independent regulatory force, but instead derive their effect from voluntary and knowing assent. Notice, too, where Mr. Landor's theory would lead. Given the explosion of spending clause legislation in recent decades, Congress would enjoy an effectively unbridled police power. Federal authorities would have no need to show that their regulations represent proper exercises of Congress's limited and enumerated powers found in the Commerce Clause, the Bankruptcy Clause, and any other. All they would have to show is that a recipient who consented to a funding condition spent some formerly federal money in transactions with a third party. Just like that, the federal government could directly regulate the third party's conduct. Take some examples. On Mr. Landor's theory, Congress could require coaches at universities that receive federal funds to permit transgender athletes to play women's sports or face personal liability in suits for damages. Likewise, Congress could bar doctors at medical practices that accept federal funds from administering certain vaccines to children, again on pain of damages. None of that fits with our system of limited and enumerated federal powers, where all others are reserved to the states and the people. The dissent criticizes us for trotting out this parade of horribles. But if this is a parade, the dissent marches right along, embracing these hypotheticals and more. In fact, as the dissent sees it, we should not engage in hair splitting over any strict direct consent to liability requirement or ill-formed contract analogy. On its view, these things are all just empty formalisms. If Congress can ask individuals to consent to funding conditions or ask states to enact laws in order to receive federal funds, Congress might as well be allowed to regulate private behavior directly. Likely enough, that vision would have delighted Gouverneur Morris. But it is one at war with the terms of the spending clause, how that clause has been widely understood since the founding, and a long line of this court's precedents. Nor is there anything empty about insisting that Congress operate within the limited and enumerated powers the Constitution provides. This court has rejected views like the dissent's many times before, and we do so again today. Faced with that problem, Mr. Landor and the dissent search for some foothold in our precedents to support their view that the spending clause grants Congress direct regulatory authority. Perhaps the best they can muster is a line snipped from Rust v. Sullivan, where we said that an individual employed in a federally funded program must perform his duties in accordance with the restrictions specified by Congress. But even that is of no help. Rust did not involve an attempt to impose personal liability on the program's employees. The only consequence for violating Congress's funding conditions fell on the federal funding recipient itself and amounted to no more than a loss of funding. And that is exactly the typical remedy for noncompliance our cases have long described. Mr. Landor and the dissent also point to Grove City College v. Bell, a Title IX case. But there, too, the only penalty was the traditional one, the termination of federal funding. Subsequent events illustrate as much. After losing the case, the college decided to exit the federal funding programs rather than surrender its autonomy, a choice it was free to make because Title IX binds only those who have freely elected to accept federal funds. Pretty plainly, neither Rust nor Grove City College purported to reimagine the spending clause's terms or to rewrite our precedents construing them. Finding our precedents under the spending clause unavailing, Mr. Landor and the dissent appealed to ones construing the necessary and proper clause. In Sabry v. United States, we held that Congress's criminal ban on theft, fraud, or bribery against a federal funding recipient is a necessary and proper incident to Congress's authority under the spending clause. Mr. Landor and the dissent contend this case is no different because personal liability for non-consenting defendants is likewise a necessary and proper incident to RLUIPA's policy protecting religious exercises. Much as the other arguments we have encountered misconceive the spending clause, this one misunderstands the necessary and proper clause. The latter provision authorizes Congress to employ necessary and proper means for carrying into execution its other enumerated powers. Put another way, the clause allows Congress to enact laws incidental to those powers which are expressly given. So the question is not, as Mr. Landor and the dissent would have it, whether a personal capacity cause of action is incidental to RLUIPA's policy protecting religious exercises. The question instead is whether their proposed cause of action is a necessary and proper incident to Congress's constitutionally enumerated power to spend money. With the question correctly framed, the distinction between this case and Sabry becomes unmistakable. Section 666 addresses thieves, fraudsters, bribers, and others who threaten to fritter away in graft the funds Congress distributes pursuant to the spending clause. The thief steals allocated money, the fraudster extracts it under false pretenses, the briber obtains it by greasing palms. Congress, Sabry held, does not have to sit by and accept the risk actors of that sort pose to its constitutionally enumerated spending power. Instead, as a necessary and proper incident to that power, Congress may punish people who seek to sap federal funds from their intended beneficiaries. And Congress may do so, Sabry concluded, even where not every misappropriated dollar may be traceable to specific federal payments. Nothing similar can be said for the cause of action Mr. Landor and the dissent propose. Suits against non-consenting parties, like the individual officers here, might advance RLUIPA's laudable policy of protecting religious exercises. But they do not safeguard from graft the federal funds Congress distributes pursuant to its spending power. Recognizing as much, seemingly every court of appeals to address the question has concluded that Sabry does not begin to command the result Mr. Landor and the dissent seek. Nor, with Sabry out of the picture, can Mr. Landor and the dissent explain how their proposed cause of action would help carry into execution Congress's enumerated power to spend money. In truth, they don't even try. Instead, they suggest the necessary and proper clause ought to be elastic enough to allow the extraction of money damages from virtually anyone who violates virtually any condition found in spending clause legislation. But while the necessary and proper clause may allow Congress to enact provisions actually incidental to its spending power, like those protecting federal money against graft, it does not tolerate outcomes that would undermine the structure of the federal government established by the Constitution. Nor does the clause tolerate results that would violate the principle of state sovereignty. And adopting the expansive approach Mr. Landor and the dissent propose would require us to violate both rules. Just consider what they would have us say. On their view, Congress may evade the consent requirement inherent in its spending clause authority simply by invoking the necessary and proper clause. With even a modest federal expenditure somewhere nearby, Congress could then proceed to regulate directly the conduct of countless non-consenting individuals, not just the individual officers here, but also others like the coaches and physicians we discussed above. Congress could regulate directly, too, in innumerable spheres, including ones traditionally reserved to the states. Really, under Mr. Landor's and the dissent's logic, we would be hard-pressed to posit any activity that Congress would be without power to regulate. And as inconsistent as all that is with both principles of state sovereignty and a federal government of limited and enumerated regulatory powers, it hardly represents a proper means for carrying into execution Congress's spending power. Under the spending clause, Congress's power to spend money does not include the power to regulate. Spending clause statutes can bind only those who voluntarily and knowingly undertake obligations by agreement with the federal government. Because that essential element is missing here, we affirm the judgment of the Fifth Circuit. It is so ordered. Justice Jackson, with whom Justice Sotomayor and Justice Kagan joined dissenting, Congress enacted the Religious Land Use and Institutionalized Persons Act of 2000, RLUIPA, to ensure that state and local prisons respect prisoners' right to religious exercise. Congress might have opted to accomplish this through contracts with the prisons it funds. Instead, it passed a law. RLUIPA requires state and local prisons that accept federal funding to accommodate prisoners' religious exercise more generously than the Constitution mandates. Like many, this law comes with an enforcement mechanism. To ensure compliance, RLUIPA authorizes an impacted prisoner to sue any prison employee who violates the statute. Such suits, the statute provides, may proceed against the employee in the employee's individual capacity and may yield appropriate relief. Neither respondents nor the court contest Congress's power to impose RLUIPA's substantive directive accommodating religious freedom. The majority, nevertheless, adopts the peculiar position that Congress is powerless to create and a state is powerless to accept the natural next step, a damages remedy against officials who violate that directive. This severance of rights and remedies is a sleight of hand. It comes by way of the majority's full-throated endorsement of a contract analogy, even though what secures the rights at issue is not a contract, but a law. Today's decision magically transforms a federal statute into an invitation to be accepted or declined, deemed binding only if each particular defendant has explicitly agreed to be penalized. No matter that laws, as opposed to contracts, don't ordinarily work this way. The trick here is the majority's effortless conflation of lawmaking and agreement-making, two different sources of binding authority. The majority's analysis is spellbindingly straightforward. Spending clause statutes are contracts, and contracts bind only those who consent. But pulling this rabbit out of the hat requires misconstruing the spending clause and the necessary and proper clause, and ignoring decades of precedent affirming Congress's authority to use the power of the purse to govern. In the end, the court reduces some of Congress's greatest legislative achievements, federal laws that secure civil rights, environmental stability, healthcare, and more, to nothing more than the wheelings and dealings of an especially wealthy private party. Because I would not so trivialize a federal statute or the constitutional powers pursuant to which it was passed, I respectfully dissent. It is not often that a real-life incident so clearly illustrates Congress's reasons for adopting legislation, or the Constitution's wisdom in enabling it. Damon Landor's Rastafarian faith requires him to let the locks of the hair of his head grow. For a Rastafari like Landor, locks are the physical embodiment of spiritual identity and connection to God. Landor preserved this connection through what is known as the Nazarite vow for 2 decades, allowing his hair to grow to his knees, and he continued for most of a brief stint in Louisiana jails in 2020. At the 2 facilities that housed Landor for the bulk of his prison time, officials accommodated his vow without incident. They did so not just because it was the right thing to do, but also because federal law requires it. This court's decision in Holt v. Hobbs held that RLUIPA mandated an accommodation for prisoners' religiously motivated beards, and thus strongly suggested that Landor was entitled to a similar accommodation. Even more on point, the Fifth Circuit, which covers Louisiana, had precedent specifically requiring accommodation of the Nazarite vow. Landor knew of Ware, and he also knew of the threat that jails posed to his hair and faith, despite it. So when he was transferred to a 3rd jail with 3 weeks remaining in his sentence, he came prepared. He carried with him a physical printed copy of Ware. Upon arrival, Landor presented the case to the intake guard. Unmoved, the guard threw Landor's papers in the trash. The guard summoned the warden, who demanded documentation from Landor's sentencing judge corroborating his religious beliefs. When Landor couldn't instantly meet that demand, 2 guards carried him into another room, handcuffed him to a chair, held him down, and shaved his head. After serving his time, Landor sued the Louisiana Department of Corrections, LDOC, the jail, the warden, the department's secretary, and John Doe officers 1 through 10 in their individual and official capacities. In addition to state law claims, he brought claims under RLUIPA as well as under 42 U.S.C. subsection 1983 for violations of his First, 8th, and 14th Amendment rights, seeking both injunctive relief and damages. Respondents successfully moved to dismiss Landor's complaint. Landor's release from prison, the district court explained, mooted his bid for injunctive relief. Landor's RLUIPA claim thus remained only by dint of his request for damages against the defendants in their individual capacities. But the Fifth Circuit precedent held that RLUIPA does not permit individual capacity suits. With Landor's remaining claims failing for other reasons not relevant here, the district court dismissed his complaint. Landor had federal law on his side, and he did everything he could in real time to ensure that prison officials knew that. We took this case to address whether Landor can seek money damages from the officials who ignored the law, held him down, and uncrowned him before God. Before us, respondents offer 2 reasons why Landor cannot obtain damages, one statutory and the other constitutional. First, they posit that RLUIPA's provision for appropriate relief against a person acting under color of state law authorizes only injunctive relief. Second, they assert that if RLUIPA purports to authorize individual capacity damages lawsuits against prison officials, Congress will have exceeded the Constitution's limits on its spending power. The majority addresses only the constitutional argument, giving short shrift to the well-established principle that normally the court will not decide a constitutional question if there is some other ground upon which to dispose of the case. The majority is, of course, correct, that the practice is prudential, not inexorable. But there is prudence behind a prudential rule. The reasons for this one include the delicacy and comparative finality of the function of invalidating a congressional enactment and the consideration due to the judgment of other repositories of constitutional power concerning the scope of their authority. So I begin by rejecting respondents' statutory argument. RLUIPA plainly authorizes individual capacity lawsuits for money damages. We have already interpreted identical language in RLUIPA's sister statute, the Religious Freedom Restoration Act of 1993, RFRA, to allow for individual capacity damages lawsuits. And RLUIPA's spending clause underpinning does not rob the statute's text of its plain meaning. Understanding this is a necessary background for Part 3, my response to the majority's constitutional analysis. RLUIPA is Congress's latest contribution to a long-running religious liberty dialogue between Congress and this court. That dialogue began, for our purposes, with Employment Division, Department of Human Resources of Orr v. Smith. Smith is a seminal case in which the court held that the First Amendment does not carve out religious exemptions from neutral and generally applicable laws. Smith recognized, however, that the political branches could shield religious exercise through legislative accommodation. Taking up the invitation, Congress sought to restore via statute what Smith left unprotected by the Constitution. The result was RFRA, which forbade states and the federal government alike from substantially burdening religious exercise without compelling interest and narrow tailoring. Importantly, RFRA was not meant to be merely advisory, like the constitutional rights it sought to imitate. RFRA needed bite. Thus, RFRA made clear that it was reinstating both the pre-Smith substantive protections of the First Amendment and the right to vindicate those protections by a claim. It did so by authorizing appropriate relief for violations of its terms. As enacted, RFRA applied to state and federal governments and their officials, but RFRA's application to states and state officials was short-lived. This court would soon invalidate RFRA's application to the states as exceeding Congress's power under Section 5 of the 14th Amendment. Partially rebuffed, Congress tried again, enacting RLUIPA. In contrast to RFRA's sweeping scope, RLUIPA focused in narrowly on two discrete areas of state and local action in which Congress thought religious freedom faced particular threat: land use regulation and institutionalized persons. Other than the narrower coverage, RLUIPA practically mirrors RFRA, its sister statute. Like RFRA, RLUIPA aims to secure redress for undue barriers to religious exercise. Like RFRA, RLUIPA features an express private cause of action, indeed one that is taken from RFRA. And like RFRA's, RLUIPA's express cause of action allows a person who suffers a violation of the statute to assert the violation as a claim or defense in a judicial proceeding and obtain appropriate relief against the government. Though neither statute elaborates on what a plaintiff can get, both specify from whom they can get it. Neither statute, that is, defines appropriate relief, but both define government to mean, among other things, an official of the relevant sovereign and any other person acting under color of the relevant sovereign's law. Thus, like RFRA, RLUIPA creates a claim for appropriate relief against an official or other person acting under color of law. As a matter of text, the question whether RLUIPA authorizes a claim for money damages is controlled by a unanimous holding this court issued just 6 terms ago. In Tanzan, we held that RFRA's materially identical terms authorize a damages claim. Our analysis was straightforward. First, we ascertained the who. We identified the potential defendants in a RFRA lawsuit, asking whether injured parties can sue government officials in their personal capacities. And to that question, we said that RFRA's text provides a clear answer. They can. RFRA authorizes lawsuits not just against a government, as colloquially understood, but also against government officials and other persons acting under color of law. This language, we noted, echoes one of the most well-known civil rights statutes, 42 U.S.C. subsection 1983, which authorizes individual capacity lawsuits against persons acting under color of any statute. With that answer in hand, we had no trouble discerning the what appropriate relief entails. We acknowledge that the term is open-ended and inherently context-dependent. But given the who, the term had an obvious meaning. In the context of suits against government officials, damages have long been awarded as appropriate relief. So too here. Indeed, Tanzan's reasoning applies with even more force to RLUIPA. RLUIPA's prison context redoubles Tanzan's observation that damages will often be not only an appropriate form of relief, but the only form of relief available. The Prison Litigation Reform Act's exhaustion requirement and strict limitations on injunctive relief in prisons, coupled with states' ability to transfer prisoners and thereby moot claims for injunctive relief, mean that withholding a damages remedy will often leave prisoners with no remedy at all. Accordingly, if RFRA's text authorizes individual capacity lawsuits for money damages, RLUIPAs must do so as well. It is true, though, that while the relevant statutory text is the same, the two statutes' fonts of power are not. It is on this observation that respondents rest their statutory argument. Unlike RFRA, RLUIPA relies on, as relevant here, the spending clause. Any divergence between the statute's meaning, then, would have to come not from text, but from constitutional inference, something particular to the spending clause, compelling us not to adopt the same reading of that same statutory language. When interpreting spending clause legislation, we have used a contract analogy to require that Congress express its intent to impose conditions on the receipt of federal funds unambiguously. Under our precedent, this is where contract law principles should come into play, not as a substantive limitation on Congress's power, as the majority uses it today, but as a demand for statutory clarity. But RLUIPA's authorization of an individual capacity damages remedy is unambiguous for spending clause purposes. Our cases foreclose any argument to the contrary. 8 years before Congress passed RLUIPA, we considered the remedies available under Title IX, another spending clause statute, but one far less clear about remedies. Where RLUIPA is strident, Title IX is coy. That statute has no express private right of action and, accordingly, no relevant remedial language. Yet we still concluded that it authorized damages. We explained that, even absent explicit statutory language, we presume the availability of all appropriate remedies unless Congress has expressly indicated otherwise. And we flatly rejected the notion that the normal presumption in favor of all appropriate remedies, including damages, should not apply because Title IX was enacted pursuant to Congress's spending clause power. Against Franklin, respondents point to Sossaman, but Sossaman cannot bear anything close to the weight respondents place on it. There, we held that the same RLUIPA provision at issue today does not authorize damages in one very particular context, one with a different who, where the defendant is a sovereign. Sovereigns enjoy sovereign immunity, and the essence of sovereign immunity is that remedies against the government differ from general remedies principles applicable to private litigants. We did not question the obvious meaning of appropriate relief in lawsuits against individuals. In short, RLUIPA leaves no need to wonder what sort of penalties might be on the table for a violation of its terms. Like RFRA, RLUIPA reinstated both the pre-Smith substantive protections of the First Amendment and the right to vindicate those protections by a claim, with an individual damages remedy where appropriate. At long last, I arrive where today's majority starts. On the majority's view, no matter how clearly Congress speaks, all that matters is the response it elicits. Spending clause legislation may not make anybody liable without their express consent. And because prison officials, as opposed to their state prison employers, have not directly accepted federal funds, they have not consented to being sanctioned for their failure to follow federal law. The majority's reasoning requires it to diminish two congressional powers and contort many more precedents of this court. Stated simply, the spending clause contains no direct consent requirement. The power it grants Congress is, of course, not unlimited, but neither is it so cramped as the majority imagines. Most important, it is a power to legislate, not merely to negotiate. And if the spending clause falls short, the necessary and proper clause supplies the additional power Congress needs to bind prison officials, state agents whose compliance is critical to RLUIPA's effective implementation. The spending clause is embedded with Congress's first enumerated power. It gives Congress the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. The authority to spend money for the general welfare naturally includes the power to determine the general welfare and to ensure that expenditures further it. Thus, Congress has broad power under the spending clause of the Constitution to set the terms on which it disperses federal funds. To exercise that spending power, Congress passes laws conditioning federal funding on compliance. The product is, of course, federal law like any other, enacted via bicameralism and presentment, and constituting the supreme law of the land. And such law may further not only Congress's other enumerated powers, but also ends otherwise beyond Congress's reach. For decades, the court has used a consistent yardstick to measure the constitutionality of spending clause legislation. We crystallized that metric in Dole. Funding conditions in laws enacted pursuant to the spending clause must be in pursuit of the general welfare, unambiguously expressed, related to the federal interest, and not in violation of other constitutional provisions. The financial inducement offered by Congress also may not be so coercive as to pass the point at which pressure turns into compulsion. When Congress exercises its spending power, we have long understood Dole provides the appropriate framework for assessing constitutionality. But neither respondents nor the majority attempts to invalidate RLUIPA under any of Dole's prongs. Instead, they devise a new one. Spending clause legislation can make liable only those who have directly and expressly consented to be made liable. This new rule starts from a kernel of truth. Spending clause legislation does not take effect of its own accord. It requires a funding recipient to accept funds and thereby to consent to the accompanying conditions. In this way, spending legislation differs from other federal law, which may command without offering. From that kernel, though, the majority sprouts a dramatic innovation. The conditions prescribed in spending clause legislation, the majority insists, may not bind anybody but the funding recipient itself, no matter the recipient's relationship to the non-recipient, i.e., sovereign, employer, or, as here, both. And no matter how essential the conditions are to Congress's spending program. This novel consent requirement discards decades of spending clause and necessary and proper clause precedent. This court has upheld spending statutes that make RLUIPA look modest in its reach. Recall that the individuals RLUIPA exposes to liability are state prison officials. These are agents of the state who voluntarily seek the state's employ and wield its power. The state, the funding recipient, thus exercises authority over them in two ways. As their employer, the state can place conditions on their employment, and as a sovereign, the state can govern their behavior. Under our precedents, either should have sufficed. With both, this is an easy case. Start with Dole itself. Dole upheld a federal law conditioning highway funding on states raising the legal age for purchasing or publicly possessing alcohol, that is, on states forbidding a category of behavior for young adults. Underage drinkers are not the federal government's contracting partners. C. O'Connor dissenting, arguing that the law was unconstitutional because it was not a condition determining how federal highway money shall be expended, but rather a regulation determining who shall be able to drink liquor. But we held that Congress could nonetheless use its spending power to regulate their drinking habits in this fashion. Thus, one needs look no further than this court's most canonical spending clause case to cast doubt on the majority's insistence on individual consent. If South Dakota can agree to criminalize the behavior of its 19-year-old bourbon enthusiasts, it's unclear why Louisiana cannot agree to make its prison officials liable for forcibly shaving Damon Landor's head. Citing Justice Oldman, dissenting from denial of rehearing en banc, the majority maintains that this is not Dole. RLUIPA is different, the majority says, because Congress has bound individual prison officials directly, whereas the federal law in Dole did not act directly upon non-recipients. Instead, that law influenced a state's legislative choices, causing the state to regulate young drinkers. But that distinction makes no relevant difference. Either way, Congress has used its spending power to regulate individuals without their express consent. In Dole, the state exposed the individual to liability in exchange for federal funds. So too here. Regardless, in subsequent cases, we have not been squeamish about recognizing Congress's authority to regulate non-recipients directly in service of protecting the integrity and proper operation of the federal program. In Salinas v. United States, for instance, we harbored no serious doubt about the constitutionality of an anti-bribery statute that regulated individuals situated identically to the prison officials here, i.e., state and local officials employed by agencies receiving federal funds. Salinas thus checked both the employer and sovereign boxes, and in Sabry v. United States, we went further still. explaining that the spending clause, buttressed by the necessary and proper clause, empowered Congress to criminalize private individuals' bribery of state and local officials employed by entities receiving federal funds. The private individuals were complete strangers to the funding relationship between the federal government and the funded entities. No matter. Congress, we explained, can bring federal power to bear directly on individuals where necessary to see to it that taxpayer dollars appropriated under the spending clause are in fact spent for the general welfare. So it is not I, but the majority, that jettisons a long line of this court's precedents. We have lived for decades in a world in which Congress has been able to use its spending power to reach beyond direct recipients of federal funds, and it has done so repeatedly. In the Federal Nursing Home Reform Act, for instance, Congress authorized civil penalties against individual employees of federally funded nursing homes who falsify resident assessments. In the Emergency Medical Treatment and Active Labor Act, EMTALA, Congress authorized civil penalties against doctors in federally funded hospitals who negligently violate the law's requirements. And in Title X of the Public Health Service Act, Congress authorized fines and imprisonment for state officers and employees who coerce abortion or sterilization by threatening the loss of federally funded benefits. These are important measures for obvious reasons. They are also required if these laws' intended ends are to be accomplished, for a state can act only through its officials, and an institution only through its employees. See Prince v. United States. To say that the federal government cannot control the state, but can control all of its officers, is to say nothing of significance. Congress reasonably seeks to ensure compliance with its directives by giving individual actors imbued with state authority a personal stake in the matter. Nothing in the Constitution prevents Congress from designing spending clause statutes in this fashion. That should spell the end of this dispute. The spending clause has no strict direct consent to liability requirement, and respondents offer no reason to think RLUIPA fails the traditional Dole test. But Congress has still more reservoirs of power from which to draw. The necessary and proper clause empowers Congress to enact laws in effectuation of its enumerated powers, including the spending power, that are not within its authority to enact in isolation. Should RLUIPA's individual capacity remedy require more than the spending clause provides, the necessary and proper clause supplies it. This conclusion flows from a concession respondents make without reservation. There is no dispute that Louisiana prison officials must comply with RLUIPA's substantive protections. Respondents, in other words, do not place prison officials beyond RLUIPA's substantive reach. Accepting that RLUIPA imposes a duty on prison officials, they just seek to exempt those officials from any of its liability provisions. There is no proper place in our jurisprudence for this wholly artificial distinction. The necessary and proper clause makes sure of it. That clause enables Congress to provide by suitable penalties for the enforcement of all legislation necessary or proper to the execution of powers with which it is instructed. So where an enumerated power enables Congress to prescribe rules, the necessary and proper clause empowers Congress to give those rules force by imposing consequences on those who disobey them. That is all RLUIPA's cause of action does. It authorizes the extraction of money damages for behavior Congress concededly may proscribe. Notably, the majority does not contest the premise that Louisiana's prison officials must abide by RLUIPA, and it admits, as it must, that a court may order prison officials in their official capacities to comply with RLUIPA. But this leaves the majority in an odd spot. In the majority's view, the prison official's relationship to the state is close enough that the actions of the official are the actions of the state itself, such that the official may stand in for the state in litigation, but distant enough that the state's consent to damages liability on the official's behalf means nothing at all. There is no rational basis for that distinction. Battling uphill, the majority reworks the necessary and proper clause. The majority contends that rather than allow Congress to enforce statutes passed pursuant to other enumerated powers, the necessary and proper clause must facilitate the enumerated powers itself. Only if a regulation is necessary and proper incident to Congress's constitutionally enumerated power, the majority insists, does the necessary and proper clause justify it. This is a deft maneuver, but not a successful one, and it diverts our focus to the wrong relationship. The relevant question is simply whether the means chosen are reasonably adapted to the attainment of a legitimate end, sought under an enumerated power, not whether the means chosen are incidental to the power itself. See Gonzalez, and then see Quevedo with Scalia dissenting. What is necessary and proper to enforce a statute validly enacted pursuant to an enumerated power is itself necessary and proper to the execution of an enumerated power. Said otherwise, we look to see whether the statute constitutes a means that is rationally related to the implementation of a constitutionally enumerated power. This is why the necessary and proper clause authorizes Congress in the implementation of other explicit powers to create federal crimes, to confine offenders to prison, and more. Not because the power to imprison is incidental to the power to, say, regulate commerce, but because the power to imprison gives Congress the ability to make its regulations effective. The majority resorts finally to abstraction, retorting that the necessary and proper clause does not permit Congress to undermine the structure of the federal government established by the Constitution or violate the principle of state sovereignty. I do not contest these assertions. It is the court's application of them here that is baffling, since exposing state officials to damages liability does nothing so dramatic. The state officials might be vulnerable to federally imposed money judgments for unlawful conduct is a common feature of our federal system. RLUIPA's imposition of damages liability for state officials comes as no surprise to states or their agents and by no means offends state sovereignty. The state chose to accept the funds with full knowledge of RLUIPA's command, and the officials in turn chose to accept state employment with full knowledge of federal law. That the necessary and proper clause may extend the reach of the spending clause, as we have long recognized, does not, of course, mean that congressional power is unbounded. But it does mean, as again we have long recognized, that where Congress may require compliance via law, it may also secure compliance via imposition of liability, including damages. I do not doubt that difficult questions about the limits of Congress's spending power exist, but as I have explained thus far, this case offered no opportunity to resolve them. Respondents seek to limit the spending clause in a manner directly contrary to our precedents, and when it comes to enforcement of a concededly proper exercise of congressional power, the necessary and proper clause supplies any authority that the spending clause cannot. Let us then step back and examine the origin and consequences of the majority's unprecedented invocation of a categorical font of power condition limiting Congress's reach under the spending clause. This limitation is not located in the Constitution's text. It is hard to imagine a broader statement of the scope of Congress's power than the spending clause. And it is not in our precedents either. Today's court cannot successfully explain the decisions of yesterday's. Rather, it appears that the seeds of the majority's dramatic weakening of the spending power were first planted some time ago and are rooted in a loose contract analogy the court has repeatedly cautioned against taking as anything more. The majority supercharges that analogy here and now, ensuring that it comes to full flower. This may prove to be a consequential choice. The contract analogy derives from the insight that spending clause legislation requires acceptance of federal funds before it can take hold, making it much in the nature of a contract. Until today, we have used that insight in two relatively modest ways, both as interpretive aids. First, the contract analogy gives rise to a clear notice requirement. Second, the analogy offers background principles to fill in gaps where a statute falls short of the required clarity. C. Cummings, explaining that a spending clause statute that is silent as to available remedies presumptively authorizes the usual contract remedies. And then C. Barnes, a funding recipient is generally on notice that it is subject not only to those remedies explicitly provided in the relevant legislation, but also to those remedies traditionally available in suits for breach of contract. But even when using the analogy for those purposes, the court has always viewed it cautiously. We have consistently refused to imply that suits under spending clause legislation are suits in contract, or that contract law principles apply to all issues that they raise. C. Cummings, declining to incorporate the law of contract remedies wholesale. Some justices have warily accepted the contract analogy in certain contexts while cautioning that it may fail elsewhere. others have protested its use as novel. Still, others have cast doubt on it as an imperfect way to interpret spending clause legislation. In all events, the court has always rejected the idea, though pressed with vigor in dissent, that spending clause legislation is nothing more than a contractual offer. At most, the court has accepted that spending clause legislation has a contractual aspect while steadfastly insisting that such laws nonetheless cannot be viewed in the same manner as a bilateral contract governing a concrete transaction. After all, unlike normal contractual undertakings, spending clause laws are statutes expressing the judgment of Congress concerning desirable public policy. Having undergone bicameralism and presentment, spending clause legislation is legislation in the end, not a buy-sell transaction. Today, the court abandons its warranted caution, and an interpretive guide becomes a substantive limitation on Congress's authority as the court takes a step toward embracing what one scholar has criticized as the strong contract theory, the radical notion that spending clause legislation is not just in the nature of a contract, but is in fact nothing but a contract. Strange as it seems, today's majority appears to mean it. One indication is the majority's concession that Congress could have lawfully imposed personal liability on the individual defendants if it had tweaked RLUIPA to better conform to the court's understanding of the limits of contract law. For example, the majority allows, Congress could have said that as a condition of federal funding to LDOC, its officers had to agree to enter separate contracts with the federal government consenting to answer suits under RLUIPA. Or, the majority posits, Congress might have conditioned its funds on Louisiana's agreement to exercise its own regulatory powers to adopt a state law cause of action enforceable against LDOC officers who violate RLUIPA. Those arrangements, the majority assures us, would have sufficed for spending clause purposes, but the one Congress chose fails because it hews insufficiently to the tenets of binding contractual relationships. Of course, the arrangement Congress chose is not far off from the untapped possibilities the court prefers. RLUIPA is no secret. Prison officials know when they sign up to work at a state prison that they must obey the law or face the consequences the law prescribes. This is simply a consequence of their decision to accept employment. What meaningful difference would it make to have them sign a contract attesting to that knowledge? Similarly, it makes no meaningful difference for Congress to require a state to flex its own legislative power to bind state officials rather than allow the federal government to make state officials liable directly, as federal law so often does. The majority, in other words, deals in form, not substance. The emptiness of the majority's formalism is further illustrated by the parade of horribles it trots out. The majority warns us that if RLUIPA's individual capacity damages provision is constitutional, Congress could subject college coaches to liability if they refuse to permit transgender athletes to play women's sports, or make doctors personally liable if they administer certain vaccines to children. What the majority intends by these examples is not clear. Congress could, of course, impose these conditions on the colleges and medical practices themselves, assuming they receive federal funds and the laws are otherwise constitutional and not coercive. Congress's reach thus remains the same either way. All that changes is whether non-compliant coaches and doctors lose their jobs, in the majority's world, or become liable in damages, in Congress's and therefore mine. So the court's ruling apparently boils down to dissatisfaction with the precise way Congress structured RLUIPA. Such hair-splitting undervalues Congress's lawmaking prerogative. We ought not substitute our rigid contract-based preferences for Congress's considered statutory design. Some play must be allowed for the joints of the machine, and it must be remembered that legislatures are ultimate guardians of the liberties and welfare of the people in quite as great a degree as the courts. Taking this wisdom to heart, the court usually exhibits a well-founded reticence to invalidate the acts of the nation's elected leaders. In my view, an ill-formed analogy to contract law is a regrettable basis on which to turn reticence into enthusiasm. Ultimately, I fear that the majority has now conjured an apparition to replace a once efficacious vision of Congress's spending power, a constitutional grant of authority that is central to the design and functioning of our federal system. History demonstrates that power's significance. Under the Articles of Confederation, the power to tax remained with the states. This arrangement left the federal government largely dependent upon the states, eager for their cooperation but struggling to secure it. Thus, one major motivation for the new Constitution was to give the federal government the tools to better incentivize states to work collectively for the good of the entire Union. Granting Congress the power to tax allowed the federal government to amass the resources it needed to dangle those incentives, and granting Congress the power to spend allowed the federal government to follow through. Follow through it has. We owe this to the spending clause, for example, Title VI of the Civil Rights Act of 1964, a law with which few pieces of federal legislation rank in significance. We owe to the spending clause, too, the relative cleanliness of our nation's air, and the relative health of our nation's populace. Other examples spanning virtually every domain of national and state policy abound. While today's decision does not endanger those laws directly, the majority's reasoning casts a shadow that will not easily be escaped. No one knows what changes lie at the end of a strict contract law construction of the spending power, but as members of this court have long recognized, importing contract principles wholesale could have potentially far-reaching consequences. Indeed, it is our rejection of the strict contract analogy that renders spending clause rights enforceable under subsection 1983. Similarly, contracts presumably may not preempt state law, yet spending clause legislation can do so. And Congress likely could not hitch its necessary and proper power to a mere contract, either. But we have blessed just this cocktail of enumerated powers. This means that today's decision might well land a serious blow to Congress's effectiveness, or it could end up merely a bothersome statutory drafting guide. If Congress adapts its spending clause legislation to fit the court's newly prescribed formulas, and if the court lets it do so, then the majority's robotic importation of contract principles will have little real-world effect. Either way, though the suggestion that spending clause statutes are not law on the same level as other pieces of legislation makes little sense. And it makes even less sense of the jurisprudence that has developed for decades around those laws, to the great benefit of the American people. As for RLUIPA itself, the consequences are more predictable. Prisoners like Landor who suffer violations of their religious freedom in state prisons, no matter how blatant, will often be left remediless. And encroachments on prisoners' statutory rights are likely to happen with fair frequency, as state-empowered prison officials will have little incentive to abide by federal law, even if it is handed to them on a piece of paper. When Sossaman concluded that RLUIPA did not expose states and their institutions to damages liability, Justice Sotomayor lamented that the court's holding left RLUIPA's plaintiffs to seek enforcement of their rights with one hand tied behind their backs. Today, the court ties the other hand. To be clear, the court's decision does not eliminate all damages liability from RLUIPA. A prisoner who happens to be housed in a local rather than state jail may recover damages from the municipality, which neither enjoys sovereign immunity, nor suffers from the indirect recipient defect the court identifies. Furthermore, RLUIPA channels the commerce power rather than the spending power in some of its applications. So the rare RLUIPA plaintiff who finds a commerce clause hook may recover damages too. But Congress did not enact such a patchwork scheme, and the Constitution does not demand it. Yet the court imposes such a scheme today. The court does so by concluding that, even where Congress can legislate under the spending clause, it may be left powerless to enforce that legislation in the way it chooses. This development is as new as it is peculiar, and it devalues precedent and congressional authority alike. Well, that was a good read, and as always, if there's any case you'd like me to read, just drop in the comments and I'm happy to take a look. Thank you.